Tonight we'll be watching, maybe even participating in, a distinctively American argument over the meaning of precisely 12 words. They can be found in Article 1, Section 8, Clause 3 of the Constitution. Here's what they are. The Congress shall have power to regulate commerce among the several states. And while the early discussion will center around the history and doctrine of the Commerce Clause, as these words are collectively known, it will quickly depart into how these words figure into a central argument of our time, the debate over health care reform. As most of you know, President Obama's prime legislative achievement, the Patient Protection and Affordable Care Act, came before the Supreme Court in March for oral argument, with the principal question being this one: did Congress, with this act, exceed its Commerce Clause powers as defined in Article 1, Section 8, Clause 3. If so, the act must be struck down. If not, the act will be upheld, with most provisions entering into effect in 2014. The court will be handing down its decision in a matter of days, but we wanted to get ahead of the story. So we invited some of the most distinguished minds in constitutional law to A, tell us what the Commerce Clause is, and B, tell us what the consequences will be to the court's decision on the Affordable Care Act, whether that decision is to uphold the act or invalidate it. I'm going to bring out our principal guests and introduce them once they get out here. Let's give them a hand of applause. In the middle here is Randy Barnett. He's the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center. He's also a well-respected Supreme Court attorney. If you hear references tonight to Race versus Gonzalez, the so-called medical marijuana case, which extended Commerce Clause doctrine, note that it was Randy who argued this case before the High Court. He is also the author of Restoring the Lost Constitution. Now, before Randy was an academic, he was a prosecutor. And in 2010, he returned to that role, albeit cinematically, when he played an assistant prosecutor in the movies. The 2010 flick was called Inalienable, but it wasn't about inalienable rights. It was a sci-fi film about a man who discovers that an alien parasite is not only growing inside him, but it shares his DNA. And in turn, he develops a fiercely paternal bond with the creature. Welcome, Randy, and welcome to your DNA. We also have Jack Balkin to my immediate left here, Knight Professor of Constitutional Law and the First Amendment at Yale Law School. And to my knowledge, he's still waiting for his Hollywood debut. Professor Balkin is the founder and director of the Information Society Project at Yale, an interdisciplinary center that studies law and the new information technologies. He's also the director of Yale's Knight Law and Media program. You can follow him on his very popular blog, Balkanization, which has nothing to do with Bosnia, Croatia, or Serbia, but with Professor Balkin's daily musings on law and politics. The conversation tonight will be guided by John Hockenberry on my far left there, a veteran journalist who knew Peter Jennings well from their days together at ABC. Today he's the co-host of The Daily Takeaway, a program produced by Public Radio International and WNYC in New York. In a departure from the usual evening program format, we've also invited several distinguished guests who are in the front row here to prod the audience. To prod the discussion. You don't need any prodding. We have Ilya Shapiro of Cato Institute, Jamal Green of Columbia Law, Stefanos Bibas of Penn Law, and Neil Siegel of Duke Law School. You'll be hearing from each of them later. So, with a thank you to all of you and to our guests, I'll turn it over to John and look forward to our evening of conversation. Thank you.
Thank you, Todd. Thank you, Todd. Thank you, David. It's always a thrill to be here at the National Constitution Center. What we want to do here tonight is to recreate the passion of that discussion about the civic issues around the Affordable Care Act that we all heard, if we witnessed, heard, or saw the arguments before the U.S. Supreme Court back in March. It was such a refreshing dose of political discourse that you don't often get in the media, a place where I work. It's a thrill to hear the arguments as the lawyers present them and as the judges hear them, and to think about the implications of issues that we will be living with, consequences of which we will be living with, depending on how the Supreme Court decides, as Todd suggested, in the next few days. It's also a thrill to be back at the Constitution Center to be reminded that Bruce Springsteen is one of the framers. It was Madison on sax, right? Ben Franklin on drums, and of course Adams played bass, but he always vocalized, so people were telling him to shut up all the time. Anyway, it's a thrill to be here and to explore freedom in its many dimensions. Let's begin, gentlemen, talking about those words that Todd spoke of, Article 1, Section 8, the Commerce Clause. How can we determine, based on just those words, what the intent of the framers was in putting in this little, by the way, federal government, you can regulate commerce among the states? Randy?
Well, John, before I answer that question, I have to two caveats, or at least two acknowledgments. One is that I'm one of the lawyers in the case, representing the National Federation of Independent Business, so the audience is able to apply the appropriate discount to the opinions that I have to offer today.
That excites us, in fact.
And
that's a positive.
And the second is that I did not play the guy who had the alien inside him. In the movie, I played a prosecutor that was trying to take the alien away from the guy. So,
that's much better.
I know. So, in answer to your question, I think what we do first off is we look at the meaning of the words on the page, and we do so in light of the contemporaneous meaning it had at the time they were enacted. This is something that's called originalism. You look at the original meaning of the words on the page, and we do that by using the kinds of primary sources, for example, that ConSource makes available to the world on its websites. And that's how we discern the intent, at least in the first instance.
And what would that be? I mean, it's my reading of American history, and again, I'm not a litigator like yourself, but it seemed to me that the federal government, or the framers, had an interest in keeping the federal government from becoming like the Hudson Bay Company or the royally empowered regulators of commerce that were associated with the English monarchy, and that therefore the federal government was to have purview over interstate commerce, but it was to stay away from and not disadvantage any of the individual states, which they believed should have their own options to enhance their wealth through commerce.
Well, if the question is not how we figure it out, but what actually the words meant, and from those words what their intention was, I think the intention was pretty well known to everyone, and that is that the previous states under the Articles of Confederation had been engaging in a lot of bad conduct, violating the rights of their own citizens, and also engaging in trade wars and protectionist legislation to beggar their neighboring state. And one of the reasons for forming a new government was to empower the federal government to do a number of things that the government under the Articles could not do. And one of the things they want to do is disempower the states from affecting interstate commerce. So the primary purpose of the Commerce Clause was to take the power over interstate commerce away from the states, because the states were abusing it, and put it in the hands of Congress, so it was taken away from them. It wasn't so much to give Congress a power to do very much with it, it's really to take the power away from the states, and it really took Congress a very long time before they started doing anything with the power they had over interstate commerce.
Jack, do you buy that refereeing function?
No, that's not really what was going on. It's part of what was going on. I mean, first of all, you started by asking a very interesting question. You asked what was the intent of the framers. And neither Randy nor I think that the intent of the framers is binding on us today. Notice that Randy shifted very quickly to asking what the meaning was, and which I think he's right about. And then he did something else, which was very important. He took some examples, historical examples, and he thought, well, what did they expect would be the consequences of writing the words the way they did? But for our time, we're not concerned so much with what they expected the consequences it would be of the words they chose, but rather what words they chose. But we're also interested in another issue that Randy has touched upon, which is what's the basic structural principle underlying the creation of a new federal government? And that question is still very much with us today. In other words, why did they create a new federal government? What were they trying to do by replace the Articles of Confederation? Randy's already pointed out one thing they were trying to do. One thing they were trying to do is deal with all of the internecine struggles between the states. But the other thing they were trying to do was they were trying to create a national government that was competent to solve national problems, federal problems. That meant especially in foreign policy. The United States didn't want to be picked off by the world's great superpowers at the time. And therefore, it was extremely important that it have all of the capabilities necessary to be a nation and to have the powers of a nation with respect to the outside world.
So then are you saying that beyond a referee function, the Commerce Clause explicitly designates that the federal government has a huge interest in commerce, whatever that might be down through the centuries?
Yes, in fact, this is certainly the Hamiltonian view. It's not the Jeffersonian view, but it's certainly the view of Alexander Hamilton. Hamilton very quickly, as soon as the ink is dry on the Constitution, has an ambitious program to try to promote manufacturers. And he wants to promote commerce, in fact. And he sees that the job of the federal government is to promote commerce and to make sure there's more of it, and that the country gets richer, and that it has active markets that work. This is his dream, in fact. This is what he wants to do. And so what you see at the very beginning of the country, first under the Federalists, but then later through the 19th century, is this ambitious program of state building. All sorts of capacities that are being built out over time. Now, during the 19th century, the state is relatively weak. Both the states, individual states are relatively weak, and also the federal government is relatively weak. It doesn't really do very much with its powers. It's really only in the 20th century, because of technology, because of technological change, that you get state building increasing both in the state level and at the national level. And that's what leads to one of the big fights over the commerce power, which occurs in the 20th century with the New Deal.
So is this case then an argument over whether a tipping point has been reached and that the federal government has overreached in this trend, in all this new technology that's come about and this explosion of commerce that Hamilton couldn't even have envisioned, that what we're arguing about is that, hey, wait a minute, you've stepped too far?
Well, I don't think it's an argument about a tipping point. I think it's an argument about different ways of understanding the obligations of the federal government toward its citizens. The opponents of the mandate, and Randy can speak for himself, but I'm going to try and put it in a particular way, believe that the secret of human liberty comes from a government that doesn't overreach too much. And by creating a balance between different kinds of governments and creating the possibility that if you don't like things in one state, you can move to another state, right? You can create a space in which people can have liberty, they can be free. And the greatest danger would be the creation of a federal government that had so much power that you couldn't escape it. There's no exit, okay? I don't know if that's Randy's view, but that's certainly a view that
Why
I agree
is the Affordable Care Act an overreach of the Commerce Clause?
Let me just pick up from where Jack left off before we get to the Affordable Care Act.
And then you have to ask me what the other vision is. But
right. I think that it's a fair characterization of part of that vision. It isn't just that you can escape, but it's because when one state does something, there's the potential of escape or exit that constrains the discretion that states have. So it's one of the reasons, one of the justifications for why states have broader powers than the federal government does, because there are structural constraints on the exercise of those powers that is simply the existence of other states that compete against it for capital as well as for people. And that constrains the exercise of this broader power. At the federal government level, you'd have to leave the country in order. The power of exit is the power to renounce your U.S. citizenship and leave the country. And that's something that people are only willing to do in extremis. And therefore, that constraint is lacking on the federal government. And then the only constraint that's sort of left, well, it's not the only constraint, but one of the principal constraints that's left, and it brings us to the Affordable Care Act, is the power of the judiciary to say that a particular law is not in conformity with the Constitution because it's not within the appropriate powers of Congress. And if the judiciary is going to throw up its hands and say, well, we can't decide, we have to defer to Congress, Congress gets to define the scope of its own powers, then really one of the only checks that there is on Congress's power goes away.
So the argument over the Affordable Care Act then becomes permitting the states to have the freedom to have a population that is fundamentally disadvantaged in terms of health by not having to buy insurance.
This really isn't a states' rights case in that sense, and in fact, I'm not a states' rights advocate, frankly. You're not going to hear me talk much about state rights. This is a scope of federal power case. The federal government has all kinds of powers available to it to address health care on a national level if people believe that that's the right policy. For example, they could adopt a single-payer system, which would basically be a Medicare for everyone system. If Medicare is constitutional, Medicare for everyone is constitutional. That is a very, very robust policy option that's available to the federal government if they want a one-size-fits-all federal solution, if that turns out to be the thing that people want. But what the government did here, what the Congress did here, is that they used a novel means, a means that, in our opinion, has never been exercised before, and in fact, no court has cited an example of where this has been done before. Let me
just stop you there. When you say novel, you don't mean, boy, that was clever. You mean a fundamentally revolutionary new power that is perhaps not exploited elsewhere.
I mean unprecedented.
Okay.
I mean a power that has never been used before. Now, the fact that a power has never been used before doesn't make it unconstitutional. But it does mean it's a case of first impression. And now it's a difficult question to decide whether this new Congress really, whether this new power that Congress has found, identified for the first time in 230 years, is a power that it actually has.
And the new power is mandating that someone buy something they would not otherwise buy but for the coercion of the federal government.
Well, it's mandating that people enter into a contractual relationship with a private company and do business with it. And that's nothing. I mean, I can prove. I mean, not only has no court who's upheld or struck down the mandate ever come up with an example, a historical example of one, but if such a mandate ever existed at the federal level, everyone in this room would know what contracts they have to enter into with private companies or pay a penalty to the IRS if they don't. And since nobody in this room, no matter how old or young you are, can cite anything, and neither could your parents and neither could your grandparents, it's evidence of the fact that this has never been done before. And now the question is this the kind of power that Congress ought to have?
Let's deal with the novel issue first. Do you think this is novel?
No, not really. I mean, the word regulate, if you want to talk about the text, the word regulate doesn't make any distinction between prohibiting people from doing something and trying to get people to do something, give incentives for people to doing something, or ordering them to do something. And from the standpoint of the text, it doesn't matter whether any of this has been tried before. It's completely consistent with the text.
So in your view, let me just back up for a second. In your view, the argument that we heard in March was making someone do something they wouldn't otherwise do is fundamentally different than regulating a behavior they're already engaged in. You say that the language of Article 1, Section 8 doesn't really make that distinction.
That distinction has no basis in the language of the Constitution.
Okay.
It's just made up for this case. But the larger point is that the distinction between action and inaction on which this case is based is one that you learn how to blow apart in your first year of law school. Let me give you an example.
Okay.
And then I want to get back to the point I was talking about before, the different vision of the federal government implicit.
But not until I have something to say about what you've just said.
I understand that.
Are you keeping score?
So it's not about keeping score. It's about trying to understand the Constitution. The Affordable Care Act basically is designed to respond to a problem, a national problem. The problem is this. The government would very much like people not to be discriminated against because they have pre-existing conditions. They don't want people to be faced with lifetime caps for their health insurance. They want to require something called community rating, which says that the underwriting for your insurance policy will not be vastly disproportionate to the underwriting for other people's insurance policies. In other words, they want to have consumer protection for people, and they want people to be able to get health insurance so that if they change their job or they lose their job or they move across the country to a new place, they can get health insurance that they can afford. That's why it's called the Affordable Care Act. But in order to do that, in order to give all these guarantees to ordinary citizens, you have to increase the national risk pool. You have to bring lots of people into the risk pool that weren't there before. Most of these people don't buy health insurance for a very good reason. They are young and they're healthy, but there are other reasons. One is that if they get sick, they go to an emergency room, they plop themselves down and say, take care of me, and then we take care of them because we're a humane society and that's what we do, and our laws also require it. And they also borrow from their friends and their neighbors and their family, sometimes bankrupting them if they get sick, and sometimes they try and cure themselves through self-help. All of these things the mandate opponents call non-action. I don't call them non-action at all. I call them acting. Borrowing from your friends and neighbors, bankrupting your family, that's action. Going to an emergency room and asking somebody to take care of you, that's action. Trying to heal yourself with self-care, that's action. So if the claim is that people aren't doing anything, that's a bogus claim. Randy, what do you think about that?
Well, first of all, you didn't hear that from me. You heard it from John. So we can deal with these one step at a time. There's at least three things I want to mention based on what you've just said. The first thing I want to note is that Jack did not dispute the fact that it's unprecedented. He went to the next step, saying, well, is this unprecedented claim of power consistent with the words of the Constitution? And that's skipping a step. I was just dealing with the fact that this hadn't been done before, and now we have a case of first impression, and then we have to ask the question of whether it's constitutional or not. So you didn't hear an example of where this has been done before, because it hasn't been done before. The second point...
You mean under the Commerce Clause, as opposed to the tax power? It's been done all the time.
Right. Well, this isn't... we can disagree about that, but this has been framed as a Commerce Clause issue, and most people, and at least the Supreme Court justices, seem to think it was a Commerce Clause issue. So yes, this is the question is whether this is an exercise of the commerce power. The second point that Jack made was that the distinction between action and inaction, which you didn't hear from me actually, is nowhere in the Constitution. This is a point that I've heard some judges make in the Court of Appeals, for example, but it's kind of a bait and switch.
Or between mandating and prohibiting. That also isn't in the constitutional text.
But this is somewhat of a bait and switch because this is a challenge that's not based on the original meaning of the Constitution, notwithstanding that's where we started this conversation. This is a challenge that's based on the doctrines, the current Supreme Court doctrines, that govern the scope of Congress's power under the Commerce Clause, under the Necessary and Proper Clause, and under other clauses. And most of that doctrine that currently governs Commerce Clause cases is not in the Constitution. You're not going to find the substantial effects doctrine in the Constitution, which says that Congress has the power to reach local activity because that activity in the aggregate has a substantial effect on interstate commerce. That is the law that comes out of the New Deal. It's nowhere in the Constitution.
All right, but let's just make a flag there for a second. We did hear that argument in the Supreme Court in March, but it wasn't about the Constitution. It was about these doctrine questions
Exactly.
that relate to the trends of the court
Right.
and the precedents up until now.
Right. So the fact that something may or may not be in the text of the Constitution has very little to do with whether it's a doctrine that would be an appropriate one to adopt in order to figure out whether Congress ought to have this new power. And I don't think the court will, if the court does strike the mandate down, adopt any broad general rule that says that Congress cannot regulate inactivity. I don't think that's what they'll do. I think what they'll say is that the power to make people do business with private companies under the commerce power, the power, as Justice Kennedy said, to create commerce in order to regulate it, is a power that's one step too far, a power that's improper under the Necessary and Proper Clause, and one that Congress ought not to have. Because if they did have it, it would be a way of obviating the political accountability that they normally have for exercising their great power like the tax power, because instead of doing something on the books that they have to take onto their own budget where they have to tax you, pay the price for taxing you, take the money into their budget and dispense it, they can just say, oh, we'll do it the easy way. We'll just make you pay our favorite clients over here directly, and then we're going to get out of the game.
Let me ask you about that.
And the last thing I just want to say
Go
about
ahead.
it is what Jack talked about in terms of this cost-shifting argument for why the Affordable Care Act is necessary. I'm not a health care policy guy. I don't think Jack is either, actually.
I've become one.
But we've all become one in the course of doing this case. But I will say this: that if this case if this law had actually been about cost shifting, if it actually had been about healthy young people shifting costs to the system by showing up in emergency rooms when they have a catastrophic loss that they can't cover unexpectedly, then, in fact, what they would have been asked to do is to buy, or they would have been mandated to do under this law, is they would have been mandated to buy catastrophic insurance coverage. But that's not what this law requires them to do. This law requires them to buy Cadillac coverage, very extensive coverage, including all kinds of health services.
Except for the bronze policies. Remember the bronze policy.
But that's just the doesn't say, the bronze policy doesn't change the coverage. It changes the deductible.
Let's not get ahead of ourselves. Are you saying that if the Affordable Care Act would only kick in if you wandered in as a non-compliant diabetic into an emergency room and tried to get care, and they said, well, we will care for you, but you have to sign up for this catastrophic health care coverage, that would be constitutional?
No, what I'm saying is that we have one bill before. We're not talking about hypothetical other bills. We're talking about the bill that the court is now considering and the rationale put forward for that bill.
Okay.
And the rationale for that bill does not match up with the actual bill, which suggests that they really were doing something other than that. And what was the something other than that they were doing? And they're doing something that the baby boomers love to do. They're raiding the pockets of young and healthy people to funnel money to the baby boomers who are not as young and not as
But you're
healthy.
not claiming that under the Commerce Clause, Congress can engage in redistributive legislation. That was an idea that was settled long ago in the early 20th century.
I am just responding to the story that you told, Jack, about what this bill is about. And I'm just telling you that if the bill had been about the story that you had told, it would have taken a different form than it did. That's all.
I disagree
And whether
with
that's
you on that.
whether that turns out to be material to the constitutional issues is really another question.
Yeah, but I disagree with your characterization of the bill.
All right, well, we will return to those issues over the course of the next hour or so. A couple of very quick questions on some of the issues you raised, and then I want to itemize the issues that are before the court, because they're going to be useful in our conversations with our interlocutors here. First of all, to your point, why this big issue over contract with a private corporation? First of all, doesn't the federal government force the states to pay for things that they don't necessarily want to pay for, which is going to come out of my pocket if I live in that state? And number two, don't I have to make all kinds of contractual arrangements with entities that involve commerce, the IRS, government agencies? Why this public-private distinction raising a constitutional question?
Well, it is an intrusion into the residual liberties or the residual powers of the people that the 10th Amendment refers to, the reserve powers retained by the people, to make people get up and go and do business with a company that they may or may not want to do business with. There is an analogy. It's not a precedent that binds this case because this is a case of first impression, but there is an analogy that the court decided some years ago, and that is whether Congress, in exercising its commerce power, can require or mandate that state legislatures pass certain laws. And what the court held was that even though Congress has very broad powers under the commerce power, it is an improper exercise of its power to mandate that states' legislatures pass certain laws. Similarly, they then later held that it was an improper exercise of congressional commerce power to mandate that sheriffs do the bidding of Congress by, for example, doing background checks for gun purchasers. And so that was another means that Congress chose to implement its commerce power that the court thought was an improper one. And this is another kind of a mandate. It's not a mandate on states. It's a mandate on you, each one of you, to exercise your own individual sovereign power to consent or not to consent to enter into a contract. And all contracts, I can tell you as a contracts professor, are supposed to be based on the consent of the parties. They're not supposed to be coerced. If they are coerced, you actually have a defense to a contract ordinarily.
All right. To you, Jack, you put forth this compelling story about the costs that are passed on to individuals from people trying to self-medicate or to get health care outside of the insurance system. But what if the federal government came up with a tremendous story about, like, we have this national problem. It's called people driving cars that use too much gas and put too much carbon in the environment, and we are going to force law enforcement inside states to confiscate those cars and require those individuals to get a car that actually satisfies our environmental concerns.
Well, if you're
they came up with a national problem. It's something that the federal government should do.
You're requiring state officials to do it?
Yes.
Yeah, well, state officials, you can't commandeer state officials.
Why not?
That's
Why shouldn't you be able to? Why isn't that?
It's a national problem.
And it's a means. It's a means necessary to the end.
Well,
what restrictions are
you're
is there?
asking me what the Supreme Court's doctrines are as opposed to how I would decide things if I were on the Supreme Court.
Anyway,
and
you want
under
to
the existing doctrines, you're not permitted to commandeer state officers.
But how would you
and
decide
the reason why you're not permitted to commandeer state officers is because it was believed that the federal government should directly act upon the citizenry as opposed to using the states as a medium. And this goes directly to Randy's point. It's a question of accountability. Now, in fact, that suggests that these doctrines that say you can't commandeer states, legislatures or executive officials, have absolutely nothing whatsoever to do with the question of whether the government can order or require or regulate individual citizens. The reason why the court believes that you can't commandeer states is that it's the duty of the federal government directly to regulate citizens. That way, everybody knows where the regulation's coming from. And I think it's really important to understand that after 2.5 years, almost 3 years of debate over the individual mandate, I don't think the individual mandate is going to sneak up upon the public unawares. I think that when you take your tax, and if you haven't seen it, as soon as you get your tax return in 2014, because it's a tax, folks, it's a tax, you pay it in your tax return, you will notice that you have to pay, if you don't buy health insurance or you don't covered by your employer, you'll have to pay a tax. And the idea is, at that point, you can make a decision. Do you want to pay the tax, which will be, about $695 by 2017, or do you want to buy health insurance? And you get to choose. And the tax is based not at the highest cost of a premium, but rather at the medium cost of a premium nationwide, which means that many people will decide they'd rather pay the tax than purchase the insurance. That was deliberate on the part of the drafters of the bill. They did not want to require everyone to purchase insurance. They did not insist on 100% coverage. Rather, they wanted to give people incentives to move toward a policy that they thought would help move us toward universal coverage.
And if a majority of the court agrees with your view, then the Affordable Care Act will be upheld. It is clear from this discussion that the mandate is at the center of the constitutional challenge here, but there are some others. The question of, first of all, is it a tax? Or is it something else entirely, a penalty?
Would you like me to read from the statute?
Well, no.
Because I can settle this question very quickly just from reading the statute out loud. I happen to have it with me. Most pundits, and I put Randy aside, most pundits have actually never read the bill they're arguing about. If you'd like, I'll read it out loud.
But that's not all 2,700 pages.
No, but the mandate. I brought the rather 2700s. They're in a cart that's over there. It says, an applicable individual shall, because most people are excluded, actually, from the coverage of the mandate. I bet you didn't know that. Shall, for each month beginning in 2013, ensure that the individual and any dependent of the individual who is an applicable individual is covered under minimum essential coverage for such month. If a taxpayer, notice the word taxpayer, who is an applicable individual or an applicable individual for whom the taxpayer is liable under blah, 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 then there is hereby imposed on the taxpayer a penalty with respect to such failures in the amount determined under subsection C, and then it's calculated. Notice that this is structured as a tax. In fact, you can't be penalized criminally for failing to pay it. No tax lien will be brought against you, no criminal prosecution will be brought against you. The only thing that will happen to you if you don't pay this tax is that it will be deducted from your refund.
Although that is precisely the issue before the court, which is a penalty an appropriate designation here if there's no injury demonstrated, and that the question of whether a penalty constitutes a tax is literally before the court, even though the government wouldn't argue that.
Well, I should tell you something interesting about the word tax. The Constitution doesn't simply use the word tax. The Constitution uses 5 or 6 different words to talk about taxes. Let me pull out my trusty Constitution here.
You know, we frisked you before you came
Yeah.
in here, and it didn't work at all.
Well, I mean, if you're going to believe in the text of the Constitution, you better have the text of the Constitution. It speaks of taxes, duties, imposts, excises, and the most important of all, revenue. All bills for raising revenue have to originate in the House of Representatives, by the way. That's so that the tax power was taken care of in the House. So that the key issue is whether or not a bill raises revenue. That's the question of whether it's a tax. It turns out the Affordable Care Act will raise somewhere in the neighborhood of $4 billion a year, and probably more than that by 2017.
But it didn't originate in the House.
It did.
One version did. The version that passed was the Senate version.
The way in which they do it in the United States,
Wait,
as opposed to
wait
different
for it.
countries.
You're going to love this when you hear how they do
the way
it.
they do it in the United States, and I just want to tell you, if you think this is not kosher, then you think most of the laws that have been passed in the last 150 years are not kosher either. What they tend to do is they take a law that's been passed by the House or created by the House, they strike most of it, and then they insert the Senate version.
They strike it all. It's called a shell bill.
Yeah.
And it's a shell game. So this is what happens when courts defer to Congress. Because basically what the court says is, look, we're not going to get into this. Congress gets to police its own. There's an actual rule in the Constitution, which
Yes.
John just cited,
Bills for revenue
which
have
says
to originate,
they have to
in the
originate in
House.
the House. So what do? They take a bill that comes over about something completely different. The Senate amends it by stripping every single word out of there.
And then they put in the Senate
and
version.
they put in, and so the Senate version is an amendment to that bill, and therefore they have supposedly complied with this requirement. Does anyone here think they've complied with that requirement? But that's what happens when the courts don't police the requirements of the Constitution, which might be what the upshot of this case is, if the court decides it's not going to police the boundaries of the Congress
And if
power.
we start policing that, then a very large number of laws that you depend upon will all be
This
unconstitutional.
argument will continue. Let's just get the last 2 issues that are before the court. Severability, Randy, just give us a quick understanding of what severability is about.
Okay, severability is the issue of whether, if the mandate, or actually the Medicaid challenge as well, but let's just stick with the mandate. If the mandate is held to be unconstitutional, how much of the rest of the bill has to also be invalidated? Now, it's only the mandate that's constitutionally problematic, but then do you separate it completely or sever it completely from the rest of the act or not? And there's 3 positions that were argued. There's the position of the trial court, which is that the mandate is inseparable from the rest of the bill for a variety of reasons I won't go into. There's the position of the Court of Appeals, which said that the mandate was unconstitutional, but it was completely severable from the rest of the bill. And then there's the position of the federal government, who argued to the court that the mandate was not severable from the insurance company regulations, the regulations being imposed on insurance companies for which the mandate was supposed to compensate them, that it wasn't severable from those, but it was so those have to go too, but then the rest of the bill can stand. So there are actually 3 positions before the court that were argued in court, and the court, because the government was arguing one and we were arguing another, the court had to appoint a friend of the court attorney to argue the 3rd position, which was the Court of Appeals position.
And finally, the Medicare challenge. the Medicaid coercion question, which really gets back to the question of can the federal government force state officers to do one thing or another. Can you describe what that challenge is before the court, either one of you, Jack?
Well, that's actually different than the cases Randy was talking about. Since the New Deal, Social Security is structured this way, and many other federal programs are. What the federal government does is the federal government goes to the states and says, we're going to give you some money, and we'd like you to spend the money in the following way. And if you don't want to spend the money in the following way, you can't have the money. Then what happens is, after time passes, the government says, oh, here's some more money, and now we want you to spend it differently than you did before. We're going to change the way you've been spending the money. And by the way, if you don't like that, then you can't participate in the program at all. Okay? So that is to say, you can't just stay with the program you've been administering before. You have to administer it. So
Which
this
is a complicated way of saying if you don't comply with the federal rules, you lose all the federal money.
You lose all the federal money. Now, in fact, this is actually not uncommon. For example, the United States said to institutions of higher education, if you don't allow military recruiters to come on campus, then you lose all of your funding. You lose your funding for scientific research, you lose your funding for everything, really, and that was, nobody had any problem with that.
Interstate highway money,
Interstate highway money.
Yeah.
Now, the question is the following. What happened was that what the United States government did in the new bill was they took the Medicaid program, which is for poor people, and in order to move toward universal care, they vastly expanded the scope of Medicaid so that it includes a whole bunch of new people, 133% above the poverty line. And what they did is they went to the states and they said, we are, in the words of Elena Kagan, Justice Kagan, we're going to throw boatloads of money at you. We are going to swamp you with money. But you have to increase the number of people you take care of in your administration to everybody up to 133% of the poverty line. And most of the states said, yippee, more money. Man, that's great, especially in a time of recession. Yippee, more money, throw it at us. Give us boatloads of money, shovel it in. But some states said no.
By most, how many do you mean? How many states are challenging this law?
About 24 are challenging.
26 are challenging, and 2 more have challenged.
Right.
One Virginia challenged separately, and
And
Oklahoma
some states
challenged.
said,
So that's
by the
28
way,
states that have objected to this.
Well, actually, they're Republican governors or Republican attorney generals. The
Well,
other
but
states...
Wait, you can't disqualify them because they're Republican.
No,
They're
but
still
you should
states.
understand that in the states where the Republican attorney general and a Democratic governor, the Democratic governor wants the money, you see? But the Republican attorney general says, oh no, don't you dare give us the boatloads of money, because it's coercive for you to give us more money so that we can help out more poor people. Their view is that that it would be like this. Suppose that what happens is you've been teaching a course at elementary school. You've been teaching mathematics in the elementary school, and you're making $30,000 a year. And one day the principal comes to you and says, we want you to do mathematics and we want you to do social studies too, and we're going to raise your salary to $250,000 a year. And you say, but by the way, if you don't teach both social studies and math, you don't get any money, because we'll find somebody else to teach them both. And we'll pay them $250,000 a year. And you know what? You say, that's coercive, I'm leaving.
There's a big difference. It's like if you were going to tell the teacher that we're going to raise your salary to $250,000 a year, we're going to fund it by confiscating your retirement account. In other words, you're going to have to pay the extra money. All these boatloads of money that Justice Kagan was saying is going to be thrown at the states are money that's being taken away from those very same states' taxpayers in the form of federal tax dollars. So what you're basically asking a state like the state of Texas...
You mean they raised federal taxes?
That's right. So you're asking what the state of Texas to do if you say, okay, you want out of the Medicaid program, fine, you go. But we're going to take all the Texas taxpayers, federal taxes, and we're going to distribute that to all the other states. So bye-bye. And if you want to have a program to help your indigent people, you're going to have to pay twice.
That's actually not how it works, but for purposes of this discussion...
I think we understand the challenge clearly at this point. And let's move on. Ilya Shapiro, please approach the bench, if you would. The challenge to the Affordable Care Act is, as has been alluded here by Randy and Jack, is the tip of the iceberg of a whole trend of doctrine within the Supreme Court in rulings that have taken place throughout most of the 20th century that has expanded the federal power regarding the Commerce Clause. If the Affordable Care Act is turned back, Ilya Shapiro, does it represent the court finally addressing the issue of whether Congress has acquired too much power in its control of commerce in the United States?
If the Affordable Care Act is what is
if it's struck down,
if it's struck
would
down,
this
well,
be a court finally saying it's too much?
It'll say that one law is affected, the Affordable Care Act. It'll say that no precedent is touched because nothing has to be overturned in the precedent to rule for the challengers here. It'll simply say the government cannot use the tool of economic mandates as a means of regulating interstate commerce.
All right.
So nothing
Please.
gets rolled back.
That's right.
So striking down the Affordable Care Act does not reverse the trend?
Absolutely not. It takes us back to the status quo ante before Obama, before the Congress passed the law. And we're back to, Raich is still on the books, the medicinal marijuana case, Wicker, all of the precedent that we're arguing about, none of it gets disturbed.
So there's a straight line from, to strike down the Affordable Care Act would not represent in any way a turn to the right or left on the part of the court?
It would be saying that this is too far. You know, we all thought, a lot of us who support Randy's position, I should say, I've filed 10 briefs up and down, including 4 in the Supreme Court, supporting the challengers to the law. So that's also my disclaimer. I have a firm position on this. But none of the briefing here has said we need to roll back any part of the administrative state or overturn any existing precedent. This is all about, you can do certain things, but you cannot enact economic mandates.
So let me just point out, if the mandate is struck down, it'll be a very important case, because it will represent the court affirming that unlike the origination clause, which says that financial tax bills must originate in the House, the court will continue to draw a line beyond which Congress cannot go, and that will be very, very important. But where they're going to draw that line is where the line existed in 2009 before this bill was passed. And we managed to get all the way up to 2009 with the line being in that place, and they're just not going to be able to move the line in any further direction.
Do you buy that, John?
Well, it depends on what Randy argues in the next case he brings.
Well, look, I can tell you what I argue in the next case I bring, assuming I ever bring another case in my life, and it is not my intention to do so. But if I were to ever bring a case...
By the way, some of the briefs that I filed in the lower courts, Randy was one of the amicuses, so one of the amici. So I effectively was Randy's lawyer at that point. Apparently I gave him such good advice that he became the lawyer himself for the actual party at the Supreme Court.
So basically what it's going to be said in the next case will depend entirely on what the court says in this case. So the court, it's certainly within the power of the justices to issue a sweeping opinion which says that, you know what, not only is this power in doubt, but there's all kinds of other powers that are in doubt, or to adopt reasoning that would undermine all those other powers. And you know what, I promise you, I make an ironclad guarantee today, if the Affordable Care Act is struck down, no such opinion will be issued by a majority. The majority will say no such thing. And therefore, if anyone like myself wants to bring another case, there's going to be very little, if anything, in that opinion on which to base an attack on any existing law, because it's all going to be aimed precisely at this law and only at this law.
Which suggests something important that the audience should understand. If that's actually what's going on, this entire apparatus was simply a form of symbolic federalism, which was designed simply to deny the health care bill from going into effect, because of the assumption that it will be impossible for the Democratic Party, because it won't get any votes from the Republicans, to assemble a bill that would provide the consumer protection for health care that it was able to assemble.
This is just not true.
But wait a second. Would the court be making an argument like that? No.
No, of course, court wouldn't. But the point is,
so how is that relevant?
Because, as I said to you in our phone conversation a couple of weeks back, the Republican Party has absolutely no interest. This is how I agree with Randy. The Republican Party has absolutely no interest in getting rid of the powers of big government that it had under the George W. Bush administration. It wants all the same powers because it wants to promote its economic agenda. And for that agenda, it will need all the same powers that it currently has.
Look,
But wait, let me finish the point. But one of the great things about making this argument in court is that they will be able to get rid of the Affordable Care Act. And then we go to square one politically. And so Randy is right. It will leave everything exactly as it is, except that you won't be able to use this particular tool, whether you're a Democrat or a Republican, in promoting your particular economic agenda. And what it means also is that you won't have certain forms of health care protection, universal health care, for some period of time, because basically you'll never be able to get the votes necessary to do it again.
I find it hard to believe, and Ilya, please address this. I find it hard to believe that the Supreme Court would have 5.5 hours of arguments. 6 hours of arguments, more than they've had in perhaps 50 years, on a case that they're going to write so narrowly that it will only applied to the pieces of paper that
Yeah.
you have in your jacket.
That's exactly right. That's the point of the whole point of the exercise.
Why they're doing this is call it symbolic or call it what you will, but it goes to the heart of who we are as a nation. It goes to the question, symbolic or not, of whether there are any principled limits on federal power under the Constitution. Because if this goes through, then it can do anything that it thinks is necessary for a broader regulation of interstate commerce.
Then you're
And
suggesting that the court does want to write new limits on the Commerce
No, it's
Clause
not.
and create new doctrine.
John, here's the important point.
Yeah.
You have to also imagine what the alternate opinion will look like. That is, if the government's argument's accepted and the mandate's upheld, then what will happen? That will represent a change. That will represent the court, unless the court can figure out a way to do it that the government itself has never proposed, that will be a recognition of something that legal academics have wanted for a very long time. And that is the idea that the court has a plenary and unlimited discretionary power with respect to the national economy. In other words, the upholding the mandate will greatly expand the power of Congress. Holding the line at no mandate is just going to be holding the line. So this is a very big and very important and very momentous a decision that's going to be reached. But not because any other law that's ever been passed will be called into doubt.
Then what happens to all those arguments that you made, Jack, that the government decides there's a national problem, it has absolutely the precedent and the ability to intervene in Congress? Do those arguments go away? Do you believe this is not going to be a rewriting of the Commerce Clause?
There is no national problem clause.
No, I
in
understand.
Article 1,
I'm
Section
just
8.
Well,
quoting
you have to
Jack.
understand that he wanted to answer your question, and now I'll answer it.
I did.
The answer is that what the court would be doing is basically creating an artificial distinction in the law, which you'll have to legislate around. And so you'll legislate around it by using the tax power and the general welfare power, which in fact this case could be decided under tomorrow. It's very easy. I just showed you how. What they're going to do is they're going to say, okay, if you had, imagine an opinion that just said if you had used the word tax instead of penalty, we would have upheld it. Well, this is completely Mickey Mouse. But the effect of it would mean that you're never going to get 60 votes in the Senate again. So as a result, no consumer protection for individuals because they didn't say the magic word. Or to use my favorite view, suppose they just gave everybody vouchers. You know, actually, I'm not that wedded to the individual mandate as the best policy choice. Use the general welfare clause to give people vouchers and then decide what to do with them. It's more freedom. There's more individual freedom. I'm all for individual freedom. That's the way you do it, but there won't be 60 votes for that either. And the reason why is because one of the two parties would love to do that, and the other party doesn't want to do that.
All right. Ilya, thank you very much. Jamal, please approach the bench. Jamal Green. So is it not the case that if this opinion is decided very narrowly on this particular law, that it would represent a huge repudiation of what the Congress was attempting to do, and that in itself is a case of significant judicial activism?
I certainly think so. I think there's a significant cost to striking down democratically enacted laws, especially laws enacted by the Congress of the United States. We're not talking about state legislation here. We're not talking about some rogue cop somewhere violating the Fourth Amendment. We're talking about Congress. And actually, I think someone could dispute this, but I think you could make a pretty persuasive argument that the last time the Supreme Court struck down a federal statute of this significance was the Missouri Compromise. Right? That was in the Dred Scott decision, which didn't go well, to say the least. And it's not an accident that that's the case, right? Striking down an act of Congress is an enormously consequential political act, and we don't do it that often, right? So one of the questions then is, well, how much deference do you actually owe the legislature? And Randy's talked about this a little bit in the course of this conversation. But there's a legitimate question of, well, was Congress entitled to rely on the Supreme Court precedents that existed at the time? Right, and I guess I could put that question to Randy, which is, right, you could make a pretty, Jack's made the case, but you could make a case that, okay, you look at the Supreme Court's precedents, right, they wanted to guarantee no discrimination, or reduce discrimination in provision of health insurance based on pre-existing conditions. They thought reasonably that the most effective way of doing that was an individual mandate. They relied on a set of Supreme Court precedents that said that, going back to McCulloch versus Maryland in 1819, you can, if Congress thinks that the means is reasonably adapted to the ends, it can do so. Now, I know you have your own problems with that particular argument, but was Congress entitled to rely on that in passing this legislation?
This is the reason why the fact that this is an unprecedented act of power is so relevant, because if it's really literally an unprecedented act of power, there are no precedents that upon which Congress can squarely rely. It's a case of first impression. There is reasoning in various precedents that go one way and reasoning that goes the other way. And if this were really an easy case, Jamal, based on the reasoning of all these opinions that would really go one way, as so many law professors once thought, we really would not have gotten this far. And we would not have had 6 hours of oral argument to decide this case. This is a difficult case because it's a first time. And by the way, Congress, when it did enact its laws, in the findings in the actual bill that Jack has in his pocket, essentially relied on the most recent Commerce Clause doctrines. The Raich case, essentially, is what they basically structured their findings around. It wasn't structured around McCulloch versus Maryland or Gibbons.
Describe, Jamal, the McCulloch versus Maryland decision. What is the issue?
So McCulloch versus Maryland is a very old, very sort of canonical case and decided by the Marshall Court in 1819. Question is, does the federal government have the power to establish a bank, even though the Constitution doesn't specifically give that power? And the court, there's some, dispute among scholars about exactly what the holding of McCulloch is, but the court basically says that you can either interpret it as saying it's inherent within the power of Congress to legislate in favor of certain enumerated ends. So legislate in favor of interstate commerce, or raising money for the Army, or various other powers that a bank is reasonably adapted to. Or you could say that there's a necessary and proper clause, which is in the Constitution, that enables Congress to do things that it reasonably believes will lead to the regulations it wants to effect. Right? And that opinion has, as I've suggested, could be reasonably relied on in Congress. Congress doesn't have to establish a particular record of relying on a particular provision. Right? That's not the tradition of the court.
Given the thrust of the question really is how much deference does the court owe Congress when Congress is defining the scope of its own power? And I think one of the assumptions of the question is that Congress actually spends much of any serious time or any time seriously considering the scope of its own power. It doesn't. It didn't do it here. It hardly ever does it. And one of the reasons it doesn't do it is because it knows there's no court looking over its shoulder most of the time. When it comes to, for example, First Amendment questions, where there is a court looking over their shoulder, then you find state legislatures as well as local municipalities and Congress paying closer attention to the constitutionality because they think they actually might get second-guessed. But where the court has given them very broad latitude and has been actually very deferential and will continue to be after this case, then Congress basically says we can do what we want, and they ask, and you have the Speaker of the House responding to a question about what authority under the Constitution was there for passing this bill, and she says, "Are you serious? Are you serious?" Well, the fact is Congress is not serious in looking at the scope of its own powers, and therefore does not deserve any deference with respect to that particular issue.
Although it doesn't say in the Constitution that the Supreme Court is required to get a reason for why the Congress believes any particular law is constitutional.
It doesn't say the Supreme Court, which is a co-equal branch of government, is obligated to defer to the constitutional judgment of another branch. It's supposed to be exercising its own independent judgment and deciding whether the higher law of the Constitution is being violated by a lower law passed by a democratically elected government.
Well, actually, McCulloch speaks specifically to this, and McCulloch says that Congress has to decide for itself what's the most effective way of achieving the ends that it's given in the Constitution. So in this particular case, to take up the point Jamal was making, Congress thought, look, we're not going to, we have these regulations, consumer protection regulations, and we think that, in fact, they're in the public interest, and there's no claim by anybody in this case that they violate the Commerce Clause or outside the Commerce power. Everybody concedes they're constitutional. And the real issue in the case was Congress thought the only way we can make these effective is by bringing in new people into the national risk pools through the mandate. And so they said, we think this is well calculated in order to achieve the goals that we are authorized to do by the Constitution. And McCulloch says it's Congress's call as to the best way to achieve ends that it's constitutionally given. And that is the very simple McCulloch-based argument for this Affordable Care Act.
Jamal, is Jack describing the sort of necessary and proper ace that the Congress can use under the Constitution to basically do a whole lot of things?
I think Jack described it quite well. Going back to Randy's point about the First Amendment, right, there's within the traditions of the court, there's an obvious difference between rights provisions and provisions that don't necessarily involve a majority trampling on the rights of some minority. Right here we have sort of two heavyweights duking it out. We have the Republican Party, which was very vociferously against the individual mandate as a policy matter, and eventually as a constitutional matter. And you have the Democrats on the other side. You have politicians, you have lobbyists, you have interest groups on both sides. These are heavyweights. This is sort of like, right, to take a hockey analogy, since it's tonight is Game 4 of the Stanley Cup Finals, right? So the lineman doesn't come in unless there's a significant disadvantage on one side, right? You let the guys duke it out, and that's right. There's a very significant justification for that, which is that right, the text of the Constitution doesn't tell us the answer to this question, right? We're all going to disagree about these sorts of things. The court traditionally has and should need a special reason to step in, and I don't see what the reason is here.
Well, that argument just proves too much. It just proves that what it attempts to prove, if you take it at its face, is that there should be no just judicially enforceable limits on the enumerated powers of Congress. There should, I mean, unless you're violating the First Amendment.
Oh, yeah, there would
Congress
still be.
No,
There would still be.
Jamal's argument, not your argument, Jack. One at a time.
Yeah.
And if you were to take that reasoning, then there shouldn't be any judicially enforceable limit. And that's what I'm saying is going to be the big deal about this case if the mandate is upheld.
Even under Jamal's argument.
If the mandate is upheld, and that is that you just look and have to see how it's reasoned. But the question will be, will there be any judicially enforceable limits on the commerce power, just like there are no judicially enforceable, just like the origination clause is not judicially enforced?
No, there's even under I disagree. He's not treating Jamal's argument with the appropriate dignity it deserves.
I agree.
Under Jamal's argument, the Lopez decision is exactly the same, because you would not be able to run the necessary and proper argument with Lopez, and that case was held beyond Congress's commerce power limits. So it is just not true that if the case comes out in favor of the government, there are no limits on the commerce power. There are several cases. One is Lopez, the other is Morrison. These cases are not going to be overruled. There will still be limits on the commerce power.
And those cases that have what Jack earlier called a symbolic limitation on Congress, those cases were opposed by the very same people that are urging the court to uphold the mandate here for the very same reasons that have been offered, and that is that Congress should have, the court should have deferred to Congress's judgment about the need for Gun-Free School Zone Act, and they should have deferred to Congress's judgment on the need for a civil cause of action for gender-motivated violence. The very same arguments you're hearing today were made against those, in support of those laws, and the court was vehemently criticized by academics as having engaged in conservative judicial activism for having drawn a limit. The same kind of rhetoric you're going to hear if the court decides to draw a limit here.
But there is a little difference between those laws and this law, and I'm sure you would understand
Well, this is a good point to break here. Jamal, thank you very much. Stefanos Bibas, please approach the bench. In fact, is it the case, and has been sort of alluded to here in these final remarks over the last couple of seconds, that if the Affordable Care Act is struck down, that it would actually represent the continuation of a trend of eroding Congress's power in terms of the Commerce Clause?
I think it's fairer to say that it would be maybe stopping some erosion rather than it be some big acceleration, precisely because we haven't seen something like this. This is just different from what we've seen. And I also think it's important to put this in historical perspective, that right now this seems like a huge deal, and every few years we get a Supreme Court case that seems like the biggest one for a generation. But in retrospect, is the country really going to look at this as if the Supreme Court went and crafted some new doctrine? I think in the long term, the country tends to be pretty comfortable, pretty willing to defer to, as long as it seems to be a reasonable judgment of the experts. Well, this is just, of course, the government has some limited powers, or, this doesn't necessarily get rid of all the limits. So it's not clear to me that they will go all the way down the slope one way or the other.
But is this a slope we've been on for a while, since the Rehnquist Court, do you think?
Well, it's clear that since the New Deal, we've been on a slope towards, more and more governmental power. And in the last few decades, there's been more of a sense that, no, we have to look very seriously. And the court has done it in some more subtle ways in recent years. We'll read this law narrowly. We'll protect state sovereign immunity. We'll make Congress be absolutely clear if it wants to do certain things. But this is a part and parcel of a renewed interest in recognizing that ours is a government of limited powers, and it's not a radically new departure.
A question for the heavyweights here?
All right, so here's the question. If we talk about the legitimacy, the way the public is going to view the legitimacy of this decision, why do you think there's any reason to fear here if the court ultimately, say, strikes down this mandate, why is this not going to be viewed as, if the decision goes either way, well, these are the experts, they've read the text carefully, it's not like they've strayed into the culture wars or something else on which every person in America thinks, well, I know my own views here. Why do you think long-term this is going to be of any significance to the public's perception of the court, either way?
Mm-hmm. Well, there are two issues, and I want to separate them out. One is, I think it'll have absolutely no effect on the court's legitimacy. Bush versus Gore had no effect on the court's legitimacy. And Bush versus Gore is the sockdologer of situations where the court reaches out to decide a question it never thought it could have decided before.
Although, will we know the Bush v. Gore verdict until there is another Bush v. Gore kind of decision, and then we'll see the credibility of the court?
Maybe, but I mean, the Supreme Court, the military is the most admired and most respected institution in American life, and then the Supreme Court is next. And Congress is at the bottom, believe me. And the presidency is a little above Congress. So the Supreme Court is not going to lose out.
Where's the press?
The press way down. Like,
yeah.
Please just.
But the second question, the point you made is important, and it's a different one. I would have thought before this got started that this would not have had the vehemence of the culture war debates over abortion and gay rights. But for reasons that are obscure, but you and I could probably figure them out if we spent enough time talking about it, this has become like the culture wars. It's been tied up with the deeply polarized nature of America. The opposition to the Affordable Care Act, its unconstitutionality has become virtually the official position of the Republican Party. And support for the Affordable Care Act, in the eyes of folks who think it's really awful, seems to be tied to lots of other sort of values that they despise and loathe. And so what's happened is that something that you and I would have taught as just a question of structure, basic structure, tied to liberty, because structure and liberty are tied together, has instead been metastasized into something that's just as vehement and where emotions are just as violent as in any of the culture war stuffs we've seen in the last 20 years. And why that is, I don't know, but I'd be interested in your view.
Randy, let me I agree with most of what Jack says about the fact that whichever way the court rules, I don't think legitimacy of the court would be affected very much. I agree with your take on that as well, with one relatively small qualification that's only happened recently, which I think is highly unfortunate, and that is that after the argument was held, the Supreme Court justices, they go and they vote. They voted the very same week. It's a preliminary vote. It's not binding forever, but they do make a preliminary vote. Had everyone gone to their respective corners and waited for the result, then I think what Jack's instinct was to be the same as my instinct was. It's a case of first impression. It means it's a hard case, and any way it goes, the court will not be faulted for whichever way it rules. But then what happened is the president went on the very next week and started criticizing the justices for if in fact they rule against him. Now this was after an initial conference vote was taken. And then he clarified his remarks the next day, and we had a whole other news cycle about that. We then had an outpouring of political punditry, both by law professors and by people in the press, excoriating the Chief Justice for the possibility that he might be responsible for a 5-4 decision that strikes down the president's signature legislation and deeply politicized this decision, culminating in a speech from the floor by the Senate Judiciary Committee Chairman, Pat Leahy, who also said that he trusts the Chief Justice is not going to engage in this. All of this happened after the case was taken under advisement. The case had already been submitted. And the problem that this creates, because of the timing, not because of what was said, not because people don't have freedom of speech to say these things, because of the timing of it, is that now, if it turns out that the court upholds the law, there's always going to be the suspicion, and if it's the fact, we're going to find out about it very quickly, that in fact one or two justices may have bent to the will of the other branches. And if that perception gets out there, that will be damaging to the legitimacy of the court. Not the whole court and not forever, but it will at least be damaging to the legitimacy of the justices, I think, who flipped, because it'll suggest that they did not stand up to the political pressure being brought to bear on them, both by the chattering classes as well as by the other political branches. And I think that's highly, highly unfortunate.
Do you buy that?
I'm not sure it'll actually be perceived that way. There is a risk. But what I wanted to end on with my last question is, we've heard some talk about the fears of how it'll be perceived and whether this will be mere symbolic jurisprudence. I want to push back against the idea that symbolism is mere symbolism. The nature of the court is that it renders a decision at one point in time. It is fundamentally reactive. It only intervenes when parties bring a case to it, which means it speaks only sporadically on these kinds of issues. What it does is going to start a conversation, right? And that conversation is going to be continued, and many more chapters are going to be written by Congress and the president before it ever comes back to the court. So rather than being pessimistic about all the negative possibilities that come out of it, why shouldn't we fundamentally be optimistic about spurring a debate that maybe was long past due, and that whether people in the Tea Party, Occupy Wall Street are being over the top in their rhetoric, maybe it's past time we had more of this conversation about what the role is of Congress and the president and the budget in the states. And so, to some extent, those people were necessary to catalyze the movement that brought this case to the court. But to some extent, the court is also contributing to a conversation that in the end may promote civic discourse in a way that maybe the president and Congress and their partisan squabbles wouldn't have done, or wouldn't have done at this high a level of principle without this kind of prodding. So why shouldn't we be more optimistic about the takeaway here?
Stefanos, that speaks directly to your metastasized rhetoric comment of a moment
That is,
ago,
he's
Jack.
telling the story of how it could turn out very well, and I hope he's right, because in fact, we've seen an example of the debate about big and small government outside the court, and it didn't turn out well. That was the debt ceiling crisis of last year. And if I was Stefanos, I'd rather have the debate be about the meaning of the enumerated powers of Congress and have it done that way than have the debt ceiling crisis over again. I think that was just a terrible, terrible self-inflicted wound on the United States.
Stefanos, thank you very much. Neil Siegel, finer interlocutor, or, as Ilya suggested, inquisitor, approach the bench.
Where's the bench?
It's right here. It's kind of a bench-like.
It's a virtual bench.
There we go, virtual
Symbolic bench.
There we go. So the motivations for the Affordable Care Act were, as you have said on many occasions, a perception that in the healthcare arena, the house is on fire and there must be something done. If the outcome before the Supreme Court is the Affordable Care Act is struck down and nothing gets done, where do you believe we're left? And why is that an argument for one or another outcome here?
Well, I think for the indefinite future, until one party controls the House, 60 votes in the Senate, and the presidency, I don't see anything getting done, which is why I think there's so much at stake, so much that turns on the outcome of this litigation. Because the status quo in the aftermath is going to be the status quo, I think, for the indefinite future. And one way to think about different ways that status quo, we might inhabit that status quo, is to take a journey 10 years from now. Right? It's 2022, and you can imagine parallel universes. In one universe, the court strikes down the entire Affordable Care Act, and in the other universe, the court upholds it in full, and it's implemented fully. What do these different universes look like? Well, there's many different considerations, but just think about it in terms of the uninsured population in the country. And here I'm going based on the Nonpartisan Congressional Budget Office's latest estimations as of March 2012. Right? So without the Affordable Care Act, there are 60 million Americans in 2022 who don't have access to basic health insurance. With the Affordable Care Act, there are 27 million Americans who don't have access to basic health insurance. That's a projected difference of 33 million Americans. Now, that in and of itself, I think, is neither here nor there. There are many difficult, significant problems that Congress doesn't have the power to address. But I think one way to put a human face on the constitutional question is to ask, under what circumstances is Congress authorized not only to be concerned about 33 million Americans without insurance, but to act on that concern through effective legislation. And I agree with Randy that there isn't a national problems clause in the Constitution, but there is a tax power, and it gives Congress the power to lay and collect taxes, to pay the debts, and provide for the common defense and the general welfare. What do we mean when we talk about general welfare? There's a Commerce Clause, which gives Congress the power to regulate commerce among the several states. When is commerce among the several states? When is it internal to a state? There's also a Necessary and Proper Clause, which gives Congress the power to pass all laws that are necessary and proper to carrying into execution the tax power and the commerce power. And by the way, this is not a case about the Commerce Clause. I think the opponents have been so successful in framing the public debate, you see it in this event tonight. This is an event about the Commerce Clause. The government needs only one hook to win. The opponents need to win 3 times. right? They have to win 3 times in a row. They have to say it's beyond the scope of the tax power, it's beyond the scope of the Commerce Clause, it's beyond the scope of the Necessary and Proper Clause. It's got to do all of that. It's about more than the Commerce Clause. Well, how do we think about this question? I think the distinction between national problems and local problems is a very good place to start. Is the problem of providing insurance to those who don't have it the kind of thing the states can deal with effectively on their own? Or are there collective action problems, interstate externalities of the kind Randy talked about existed under the Articles of Confederation before the Constitution that would impede their ability to do so? What do we know? We know insurance companies operate in multiple states. Some of them operate nationally. And so they can and have moved from states that guarantee access to insurance to states that allow them to deny coverage based on pre-existing conditions. We know that their ability to function in marginal markets in one state is affected by their overall capital reserves. And their overall capital reserves are affected by the costs and the losses they have to bear in other states. We know that people access health care in other states. So we're in Pennsylvania. In southwestern Pennsylvania, people make about 1,500 emergency room visits each year to the West Virginia University Hospital. Situations like this are replicated all over the country. We know people are locked into jobs that they would rather not have because they can't afford to move interstate and lose their health insurance.
Well, you've made an articulate case for Congress to re-examine the question of legislation to address this problem.
No, but the question is...
Specifically, how is this relevant to the arguments that Randy and Jack have?
Because it explains why this is a regulation of commerce that's among the several states. It explains why Congress is acting, and I agree with Jack, this is a tax. It's a tax that serves the general welfare. It speaks to the basic structural question of why we have a federal government. Is it a problem that the states can deal with on their own, or is it an interstate problem, a national problem? That's one important limit on federal power that if the court upholds the Affordable Care Act, will be respected.
Randy?
Well, Neil has a whole collective action theory of the commerce power, collective action theory of the enumerated power, which is very interesting. It's getting a lot of attention. I myself am not persuaded that we have a collective action power in Congress rather than the enumerated powers, which may have, and Jack and I have had a similar debate over whether there was a more general principle that got enacted rather than specific enumerated powers that attempted to handle particular collective action problems and other problems.
Can I just sort of sort out the jargon there and I'll let you finish? Collective action, is that a kind of a national problem clause theory that you're talking about there a little bit?
It's, in other words, problems that the federal government is better situated to deal with than the states in virtue of the interstate scope of the problem.
The humongous problem doctrine.
You remember that at the very beginning. You remember at the very beginning of this discussion, I said there were 2 different visions of the federal government, and then I laid out Randy's vision, and then I said you were going to let me come and talk about my vision at some time later. Well, you finally got around to it. The idea is the reason we have a federal government is to solve federal problems. The reason why we have a national government is to solve problems that only a national government can solve. And the argument that he's just made is an argument for why health care, like Social Security and other social safety net programs, has to be done at the national level. It's because we have a mobile population and because businesses are mobile too. And so it's very important to have a single solution at the national level so that everybody can participate in these benefits.
Okay, now that's one side of the academic debate, and that is a position that academics have held for a very long time.
It's actually a position that was held at the time of the founding. That is, the distinction that Randy and I, the discussion we're having, is about 2 different notions of what a constitution is about. And so far we've been playing on Randy's turf, talking about Randy's turf of limited and enumerated powers. But in fact, most of the people who signed the Constitution, they were trying to get away from a very limited and weak government, because the limited and weak government they had brought the United States to the brink of destruction. They wanted a national government to solve national problems.
And there were not the votes. There were simply not the votes in this country to have a national problems clause, of national problems power.
But Randy, don't you make it easy for yourself by characterizing my view, Jack's view, the other side that way? Of course there's no national problems clause. So insofar as we're relying on it, we're just making policy arguments that are better directed at the legislature, not at the courts. We're just making up stuff. We're not doing law. But in fact, I've told you about the language in the tax power and the language in the Commerce Clause and the language in the Necessary and Proper Clause. It doesn't mean if you have a national problem, you throw that language out. You still have to interpret it. It could be a collective action problem, but it may not be commerce. It may not be commercial or economic in nature. That could be a separate and independent limit. right? It may
Well,
not
first of
be a
all,
tax because it may be so coercive.
Commerce was not a broad enough category to reach all economic activity, as you know.
But I don't think it's a distinction between those who take the particular enumerated powers seriously and those who don't. I think
It's two different ways of looking at the enumerated powers and what they're for.
And we can continue this issue because we're going to open it to questions in a moment. If you have a question, raise your hand. One final question to you, Neil. Do you say, by the sort of collective action doctrine that you're talking about, that if the Affordable Care Act is struck down, that essentially that opens the way for challenges to things like the Affordable Care Act, to No Child Left Behind, to educational policy, to federal roles in transportation, in all kinds of realms where similar mechanisms are at work?
I think it depends very much on how broadly they write the opinion. I think on the one hand, Randy and Ilya are urging that this could be very, very narrow, which raises the question of whether or not this limit on purchase mandates is created just for purposes of resolving this litigation, as opposed to some deep commitment to constitutional theory. But I think if you say the label matters and you got to call it a tax to use the tax power, that could have implications. If you say that Congress can't regulate inactivity, which I agree with Randy, they're not likely to say, that has major implications. If you impose limits under the word proper in the necessary and proper clause, we've heard talk about Congress can't solve problems of its own creation. Congress does that all the time. That could have major implications. So I think it really depends upon how broadly they write the opinion.
John, before Neil, I know we want to go to questions now, but before Neil launched into his collective action theory of the enumerated powers scheme, he made a first point that I was really trying to get back to. I was trying to put that to one side, frankly, and get back to his earlier point, which is an assumption that if the law is struck down, that's going to be it. There isn't going to be any legislation on the health care problems for a generation. And I just don't think that's true. In fact, I think the timing of this decision could not have been more fortunate for the point of view of actually getting a national political consensus in favor of health care reform if the law is struck down, and that is happening right in the middle of a presidential campaign, which means the next presidential campaign and the next congressional campaign is going to have to be about, now what do we do? And whichever party wins, that debate is going to come in with a mandate to do that thing.
Other kind of mandate.
I didn't say the next generation. I said the indefinite future, and I hope Randy's right.
The indefinite future will begin in January of 2000.
But Randy, for you to be right, the Republican Party, right, which has bought your constitutional argument in its entirety, even though they're the ones who came up with the idea of a mandate in the 90s, for you to be right, then there has to be serious interest on the Republican side to do something about the crisis of health care in this country.
Look, I'm not a Republican. I don't speak for the Republicans. And I sort of resent, actually, the idea that this is considered this lawsuit is a Republican plot of some kind. But it was brought on behalf of the National Federation of Independent Business, for example, a private party. But beyond that, I will just say that I do think that the Republican Party, as far as I can see as an observer, is going to be interested in having fundamental health care reform. I mean, you say they're going to have to get 60 votes to overcome a Democratic filibuster, assuming they take control of the Senate. I don't think that would be necessary. I actually think that if this gets struck down, there are going to be common sense health care reforms that do not try to take over and rework and re-engineer 1/6 of the nation's economy, which is what this monstrosity did.
All right. First of all, let's give a hand of applause to our interlocutors, Ilya, Neil, Jamal, and Stefanos. And, of course, to Jack and Randy. Questions? We begin.
Hi, my name is Daniel Pollock. I would just like to address the constitutionality of, I guess, my personal situation, which I think is somewhat relevant, and how my constitutional rights have not been violated by this. I don't believe that it's a tax based on numerous constitutional decisions and based on the fact that Congress, in the original versions in both in the House and the Senate, used tax in the specific session. In that specific section and then took it out. The fact that tax is used numerous times in all of these other sections and is taken out of this specific section. I just graduated from law school and I just lost my insurance because of that. I know under the new plan you get extended a little bit. So over the next couple of months, now I know it would have to be 2 years longer, but if this was in 2014, so essentially people who are 1Ls now, they would not have insurance for June and July. They would then have to go and pay $500-600 a month for that out of their pocket. Now, for those of you who study for the bar, this is the only break I'm taking all week. I walk 3 blocks, I have to cross 3 streets and take a trolley to get to school, and I spend all of my time in my apartment or in school. It is very unlikely that anything is going to happen to me poorly, and that I would need health insurance, yet I'm going to have to spend $1,000 to $1,200 doing that. And I see that as a direct violation of my constitutional rights. And then quickly, I know I'm not supposed to ask too, but as to Professor Green's point on congressional deference and dealing with things like that, to what extent does the fact that Congress didn't take this bill quite as seriously as they could have? It's 2,700 pages long, and I wrote a paper, Professor Barnett, and I've actually printed out and seen the 2,700 pages, double-sided. It's really, really thick. How is it not considered that the student exemption would not be continued from when somebody graduates law school until they have to take the bar exam? The reconciliation, all of these other things, does that affect the fact that the Supreme Court should pay less deference to Congress when it's clear they didn't really do their homework on that? I mean, to me, it's shocking that you graduate law school and while you have to study for the bar to become a lawyer, yet you lose the insurance, which was a big part and a big selling point of the Obama plan. Thank you.
Well, he personally feels that this is coercive, and you would obviously agree with that.
I didn't understand. I thought he was complaining about the fact that he wasn't going to be covered over. And he also thought his constitutional rights were violated. Could I ask you a question? Can you come back for a second? Take the because I didn't understand what you're saying because you're making points that went in opposite directions. So the question I guess I need to know from you is this. You just finished law school, right?
Yes.
What's the constitutional right of yours that was violated? Because I think you've got an argument, but I want to know what the argument is.
Sorry, there were two separate questions. The constitutional right is that, well, it'll be 2014 because they don't have to do it right now. Would that be that I no longer have insurance?
Yeah, I know, but you just finished law school, so talk to me like a law professor. What is the nature of the constitutional right that's been violated?
That I would have to go out and buy health insurance, or else it would violate the law.
What individual right of yours is violated by a requirement that you buy something? I think it's freedom of contract, isn't it?
What?
I think it's freedom of contract. I think the individual right that's violated that you're explaining is that you're forced to engage in a contractual relationship with another, which violates your right not to contract or not to contract.
Yes.
Right? Good, very good. Now, you just finished law school. Under existing Supreme Court precedent, what level of scrutiny is given to regulations of freedom of contract since the New Deal?
Well, there's two separate things here.
I know that, but you told me that a constitutional individual right was violated. So I'm just asking you how that would be resolved under existing precedent. It would be rational basis, wouldn't it?
Well, there is no existing precedent. That's the point of it.
No, wait a second. I thought West Coast Hotel had overturned Lochner. Isn't that right?
What? Were they forcing somebody to do something in Lochner?
Yeah, actually, in a sense, they were telling the guy who ran a bakery that he couldn't make his workers work more than 60 hours.
He was running a bakery. He took an initial action. There was
I know, but
initial reaction.
I understand your point, but you made your argument not based on federalism, but based on individual liberty. And so the argument you were making is the same argument that Joseph Lochner was making in Lochner. He wasn't making a federalism argument. He was making a liberty argument.
But look,
now, if he had made a federalism argument, which is that it's beyond federal power as opposed to individual liberty, that is your constitutional rights, that would be the debate that Randy and I are having. But you said to me that your constitutional rights were violated. Now, do you still think your constitutional rights were violated, or do you just think it's a federalism problem?
Let's get Randy's response.
He's up on him, Jack. He's up. Federalism and liberty are not unrelated to each other. Federalism is a means of protecting liberty.
But those aren't constitutionally protected rights.
I understand.
You and I agree about this, right?
We do agree about this.
So I just wanted to understand if you were actually making a rights claim.
Okay, Jack, back. Me. Okay.
Yeah.
So, the
let's get
federalism is a means of protecting individual liberty. It's a perfectly appropriate statement. I mean, the problem is he's a law student or a law graduate, but it's a perfectly
the problem is he's a law graduate.
The problem is he's a law graduate.
Because it's perfectly appropriate for a citizen of the United States to complain that their liberties are being impeded by the fact that Congress has exceeded its enumerated powers.
Yeah.
I agree with you. But
he said he just graduated from law school.
You don't have to be making a technical individual rights claim under the Constitution to make that observation. I think that's all that he was saying.
Well, actually, no. What he did was he went through a series of technical arguments about the meaning of tax, And then he told me how he read an entire long statute, and then he made what appeared to be a constitutional liberty claim. Now, the reason I'm going on about this is I think that what's behind a lot of the opposition to the individual mandate is a claim that your freedom of contract is being violated, that it's a violation of an individual liberty of freedom of contract. It's not what Randy argued in front of the Supreme Court. It's not, but it is, I think, culturally, what's at the basis of this dispute.
No, but here's
All right. Let's get a question from the front row here. Certainly, we haven't settled this question of individual liberty, and it will come up again. Go.
Thanks. Lori Ann Updike-Toller. I'm so
Hi.
grateful.
It's so nice to see you again. How are
Great
you?
to see you. I'm really grateful that both of you accepted my invitation to come tonight. It's wonderful to see this event come to pass, and the National Constitution Center agreed to do this. We started with original understanding, and I wanted to return to that. Of course, I'm sure you're anticipating my two questions. One, with all of the precedent and doctrine surrounding the Commerce Clause, are primary sources relevant to the argument? Two, if so, which primary sources are most relevant to the various arguments that the two of you are making?
And you mean primary sources on original intent?
The documentary history of the Constitution.
Got it. Okay.
You want to start with that one?
No, I'll let you go.
Okay. The problem is that Randy's arguments in front of the Supreme Court were not primarily originalist. They were based on precedent. And indeed, what's interesting is that most of the discussion of the debate over the individual mandate has not been based on originalism. It's very interesting. It's surprising to me, I would say. The briefs that were made on both sides, most of them were not about originalism. But in fact, you could have done the whole debate through originalist sources, and you could have done the whole debate through originalist arguments. And indeed, in some sense, we have rehearsed some of the arguments here about the vision of the Constitution. What was the constitutional vision about? What was the purpose of enumerated powers? And in articulating those contrasting visions of the Constitution, that is, a vision of limited enumerated powers, which protects individual liberty through gaps between what the federal government can do and what the states can do, or the idea that we need a national government that's equipped to solve national problems of governance. Those contrasting visions, which I would say are Jeffersonian and Hamiltonian, in order to understand those ideas, we have to go back to the original source material. We have to look at the debates in Philadelphia, here, and the debates in the state conventions. We have to look at the early practices of the first Congresses and the early decisions of statesmen talking about the meaning of the Constitution, and I think they shed enormous light on the different visions of the Constitution. Now, as you can probably tell, I'm taking a more Hamiltonian line. And as you can also probably tell, Randy has taken a more Jeffersonian line. And that's fine, because Jefferson was the founder of the Democratic Party, and that makes me feel very good.
Randy.
I really agree with pretty much everything Jack just said. But I do want to just sort of underscore the one thing he said, and that is that the lawsuit has not been based on original meaning, because it hasn't been. And then the reason for that is because it's a lawsuit. And if you litigate these matters, as I did in the Raich case, the Raich case was exactly the same. It was also not based on original meaning. You have to make arguments based on existing doctrine, or you have to ask the court to overturn a precedent, which if you try to win a case doing that, you're very, very likely to lose. And so that's the reason why this case has been couched entirely in terms of doctrine. But standing behind it, of course, are these first principles that we've discussed tonight. And I think the big first principle is, will the court continue its role of policing the limits of the enumerated powers, or will it withdraw from the field and allow Congress a basically unlimited power to solve national problems? And I think that's what this case will turn out to be about.
Gentlemen, and I include you four here in the front before we go. How's it going to turn out? Give me a number.
5-4.
5-4 affirmed or 5-4 struck down?
With the deciding vote by Kennedy, 5-4.
Jamal.
6-3 to uphold.
6-3 uphold.
5-4, all struck down, not severed.
Definitely Kennedy in the majority.
Then that's all you're going to say. Jack.
I'm always wrong.
So tell us so we know.
Well, I'm always wrong. I predicted long ago it would be 6-3 upholding. I'm always wrong. Therefore, do the math.
Okay. That's what I wanted to know, the essential fact there. And Randy?
And I've been at this game for over 2 years, and I've been a lawyer in the case since before the 11th Circuit, and I have never made a prediction on the outcome of this case, and I'm not going to start tonight.
Even a number? Will it be a split decision, or will it be
I'm not going to make a
He's
prediction.
not going to
on
make
the
a
outcome.
prediction.
All I can say is, which is what I tell all reporters who ask me this question, is that I thought the oral arguments went very well for us. And when I walked out of the Raich case, having argued that case, I did not think the oral arguments went very well for us. And I can tell you it feels better to have them go well than to not go well. And other than that, I can't tell you.
Randy Barnett, Jack Balkin, thanks so much. Thanks to all of you.